and that is that, under Article 1, Section 3, Clause 6, the Senate's given the sole power, and with it the sacred responsibility and duty, to try all impeachments. Now, as I've just described, in every circumstance where there wasn't some jurisdictional defect, and by that I mean a bona fide subject matter jurisdictional defect such that we lacked jurisdiction to move forward, we've proceeded and reached some kind of a verdict in every one of those cases, but not today. Mr. President, I'd been concerned for weeks. I'd heard rumors for weeks that what was going to happen today was that the majority leader was going to approach these articles with a certain degree of cavalier indifference and offer up a motion to table. I immediately became convinced after looking at the rules and studying the precedent on this that a motion to table would be inappropriate here. Be inappropriate because, for the same reasons I've just explained, we've never done that, never done anything close to that. The closest precedent for something like that was so far off course that it couldn't even be relied on. I recall the only precedent that even sounded like the same thing was in fact very different from that, in that during the trial over the impeachment of President Andrew Johnson, one senator had made a particular motion to do a particular thing during that trial, and another senator later moved to table that motion. There was no motion to table any articles of impeachment. In any event, I became convinced after studying this that a motion to table would be without precedent and, contrary to everything I thought I knew about our rule constitutionally and otherwise to conduct impeachment trials. I also became convinced that this would be bad precedent and that it would set a certain precedent suggesting that it's okay if the party occupying the majority position in the United States Senate didn't want to conduct a trial, that it didn't have to. It could just sweep them aside. As I say, channeling the immortal words of Rush in the song Free Will, if you choose not to decide, you still have made a choice. You've made a bad one if you choose to just set aside the impeachment articles without rendering a verdict of guilty or not guilty, whether pursuant to a motion to table or otherwise. And I thought a motion to table would be an especially bad basis, an especially bad strategy and a bad mode for disposing of and otherwise addressing articles of impeachment. It's important in this context to remember that the United States Senate has exactly 3 states of being. We exist at any given moment, either in our capacity as legislators in legislative session, secondly, in executive session, where we consider presidential nominations, and also on occasion treaties for ratification, both executive functions carried out under our executive calendar. Our third state of being exists in this context, where we are to operate as a court of impeachment. It's solely in our capacity as senators sitting in a court of impeachment that we're administered a second separate oath, different from the oath that we all take each time we're elected or re-elected to the Senate. It's a different capacity, and it's a capacity that requires us to decide the case and to do so on the merits of the case. It's also unique in that it's the only mode in which there is a solid expectation, unblemished until today, in which if we do, in fact, have articles of impeachment over which we have subject matter jurisdiction, and the case hasn't been rendered moot, where there is an expectation backed up by history, tradition, precedent in the text of the Constitution, that we will do the job. That, in fact, according to these precedents up until today, that we will reach a verdict of guilty or not guilty by the time that we're done. You see, those things don't exist in the other two states of being. In our legislative calendar, there's no expectation or tradition or precedent or implication from the text of the Constitution that we will affirmatively act upon and ultimately dispose of every piece of legislation presented to the President, to the United States Senate. We don't do that. We've never taken that approach. And if we did, it would, would grind the place to a halt. I don't think it would physically be possible. Nor has that ever been the expectation on the executive calendar. Sure, we tend eventually to get to most of them, but there is an understanding that unless or until such time as we confirm a particular nominee, that nominee is not confirmed, such that if we get to the end of the road, the end of that Congress, the end even of a session, if that person is to be confirmed, that person is to be renominated first and then considered by the Senate. But even then, there's no guarantee as to any final vote disposing of that nomination. This is different in the context of an impeachment, where we sit as a court of impeachment. We sit as a court of impeachment, and in so doing, we become two things. In any trial, in an ordinary court, there are two functions that a trial involves. You've got to have finders of fact. That's a role typically played by a jury in our system, both in civil courts, civil cases, and in criminal cases. And you've got to have judges of legal issues. Typically, those are performed by a judge. In some cases, most commonly, if the parties agree to have the issues of fact decided by a judge rather than a jury, then you can have the whole thing, the issues of fact and the issues of law decided by a judge. We serve both functions. We're finders of fact and judges of the law relevant to the impeachment case before us. I think, Mr. President, that's the whole reason why we're given a separate oath for that. We don't take a separate oath every time we bring up a bill or every time we get a presidential nomination or every time we're asked to consider a treaty for ratification. But we do take a separate oath every time we receive articles of impeachment. And it's not just because these things are more rare than bills as they're introduced, or nominations as they're received, or treaties presented to us for potential ratification. It's because it's a sacred responsibility in which there is an expectation backed up by centuries of tradition, custom, precedent, and understanding of our constitutional text that we'll dispose of the case. We will dispose of it in a way that culminates in a finding of guilty or not guilty, except in these rare instances where we lack subject matter jurisdiction, most commonly because the case has been rendered moot, which it is not in this instance. The particular way in which we went about this today really was crazy and impossible to defend. Absolutely impossible to defend on its merits. Remember, there were two articles in these impeachment charges. Article 1 alleged that in 8 or 9 different instances in which Secretary Mayorkas had an affirmative legal duty to detain illegal immigrants pending adjudication of either of their asylum claims or of their argument that they might be entitled to some other form of relief, including immigration parole. The Secretary of Homeland Security had an affirmative duty to detain them while those decisions were pending. 8 or 9 different statutes require that, and 8 or 9 different statutes he deliberately violated. He did the opposite of what the statute required. And by doing that, he invited and facilitated an invasion at our southern border that's unprecedented in American history, that's been dangerous, that's resulted in all kinds of heinous crimes being committed, loss of life, loss of innocence, loss of property, many, many harms occurring as a result of this, occurring as a result of his deliberate decision not only not to do the job he was hired to do and that he swore an oath to perform well, but to do the exact opposite of what the law required. I mentioned a little while ago the writings of Justice Joseph Story, one of our early Supreme Court justices a couple of centuries ago. He's familiar with the Constitution at a time closer to the founding, and also very familiar with the English legal antecedents on which the Constitution was predicated, with the legal terminology incorporated from English law into the American constitutional system. And in his great treatise on the Constitution, in section 798, he explained a few things about impeachable offenses. And he said in section 798, quote, "In examining the parliamentary history of impeachments, it'll be found that many offenses, not easily definable by law, and many of a purely political character, have been deemed high crimes and misdemeanors worthy of this extraordinary remedy," close quote. This extraordinary remedy, of course, referring to impeachment. It then recites a litany of things that would qualify for this. And again, he just noted they don't necessarily have to be easily definable by law, and they are of a political nature, but he identified some of those things that had been established through English legal precedent, English parliamentary precedent, as worthy of impeachment, qualifying as high crimes and misdemeanors. Among other things, he identified what he referred to as attempts to subvert the fundamental laws. Attempts to subvert the fundamental laws. Well, this could have broad application in all sorts of areas, but I can think of few laws more fundamental to our republic, to our federal legal system, than our fundamental laws governing who may enter this country and under what circumstances. He went on to identify a number of other things that fit this definition, adding to it, among other things, by saying one thing in particular that would meet the definition of high crimes and misdemeanors and would thus be impeachable would be an instance in which, quote, "a Lord Admiral may have neglected the safeguard of the sea." So some on the other side of the aisle have argued that, well, really what Secretary Mayorkas did was to just not do as good of a job as he should have and could have in enforcing the law. And that can't be a basis for impeachment, they argue. Some of them will invoke a line of reasoning that says maladministration, in other words, not doing your job well, isn't a valid basis for an impeachable offense. I'm not at all sure that that argument, even stated in the abstract, is accurate. In fact, I tend to think that it's not, because the Constitution itself assigns that job to this branch of government, to the House, as it assesses whether to charge something as impeachable, and to the Senate as it assesses whether an impeachment passed and presented by the House warrants conviction, removal from office. That really is our job, and as Justice Story noted, it includes offenses of a political character, regardless of whether they would amount to independently prosecutable criminal offenses in a criminal court of law sense of that word. But in any event, this is, even if you buy into that reasoning, there are those scholars who believe that. I seem to recall Professor Alan Dershowitz, the respected Harvard law professor, from whom we've heard in past impeachment proceedings. I believe he believes in this approach. But even under Professor Dershowitz's approach, he's someone for whom I have great respect, even where I disagree with him. Even if you were to accept that premise, this isn't just that. This goes far beyond just maladministration. It's not just that Secretary Mayorkas didn't do as good of a job as he could have and should have, and we wish he would have. It's that he willfully subverted what the law required and did the exact opposite of what the law required. That's impeachable. It's got to be impeachable. And yet, the majority leader stood up today and he said, I raise a point of order that impeachment Article 1, again, impeachment Article 1 is the part that deals with Secretary Mayorkas' decision to do the exact opposite of what the law requires. The majority leader continued, impeachment Article 1 does not allege conduct that rises to the level of a high crime or misdemeanor as required under Article 2, Section 4 of the United States Constitution, and is therefore unconstitutional. I don't know how he gets there. He can't get there except by sheer force, and the way you do something by sheer force here is you produce a simple majority of votes from senators declaring the impeachment equivalent of defining the tail of a dog to be a leg. What I found even more stunning was when, as stunning as that first move was, and as disappointing as it was that a simple majority of United States senators, all from the same political party, I would add, not my own, he somehow managed to outdo that one by later making the same point of order with respect to Article 2, arguing that, he said, quote, I raise a point of order that impeachment Article 2 does not allege conduct that rises to the level of a high crime or misdemeanor as required under Article 2, Section 4 of the United States Constitution, and is therefore unconstitutional. Let's remember what Article 2 was about. Article 2 charged Secretary Mayorkas with knowingly making false statements to Congress, as Congress was carrying out its oversight responsibilities, with him testifying, often under oath, to Congress. Now, unfortunately, we never got to hear any evidence on this. Therefore, we weren't presented with the opportunity to make a final determination on this. But we instead have the majority simply roll right over all of this by just declaring ipse dixit. It is because it is. It is because we say it is. That it's not an impeachable offense, even if, as has been alleged, and as the House impeachment managers, the House prosecutors, as we sometimes call them, were denied the opportunity to try to prove that he knowingly made false statements to Congress. To say that that's not impeachable is breathtakingly frightening. We've now established a precedent in the United States Senate that if you occupy a high position of trust within the United States government, a cabinet member in this instance, and you knowingly, willfully make false statements to Congress, as Congress is trying to get to the truth about what you're doing in your job and whether or not you're faithfully executing, implementing, and enforcing the law, that lying to Congress in that sense, even under oath, isn't an impeachable offense. That precedent could suggest that we've now effectively immunized from impeachment, doing that very thing. How are we to conduct adequate oversight if even the theoretical threat, the theoretical, hypothetical, potential threat of impeachment isn't on the table? It severely weakens the fabric of our republic. It certainly weakens the ability of the United States Senate to push back on abuses by and within a coordinate branch of government. You know, when James Madison expressed in the Federalist Papers, among other places in Federalist 51, that government is sort of an experiment. It's an exhibit. It's a display of human nature. There and in other Federalist Papers, he explains things like the fact that, as he continued in Federalist 51, that if we as human beings were angels, we wouldn't need government. If we had access to angels to run our government, we wouldn't need all these rules to govern those responsible for government. But alas, we're not angels. We don't have access to angels to run our government, so we need rules. Madison was also a big believer in the fact that because we're not angels, we don't have access to angels to run our government, and we do need these rules, you've got to set up a system in which power can be made to check power. And you set up each branch with its own set of incentives to guard against abuses of power. I've wondered over time as I've seen the United States Senate gradually but very steadily over many decades voluntarily relinquishing its power. Much of it started with our work on the legislative calendar, starting in earnest really in the 1930s, but continuing to the present day. We've gradually, steadily been outsourcing a lot of our lawmaking power to unelected, unaccountable bureaucrats. Pass all sorts of laws saying essentially we shall have good law with respect to issue X, and we hereby delegate to department or commission or agency or functionary Y the power to promulgate rules carrying the force of generally applicable federal law as to issue X. Little by little, the American people lose control over their own government as this happens. Little by little, you start to see this diminishes the overall accountability of the United States government. And when agency or Department Y promulgates a particular rule carrying the force of generally applicable federal law, people understandably, predictably, very consistently come to us to complain, saying this is killing us. This rule made by unelected, unaccountable bureaucrats is now going to shut down my business. I'm going to be deprived of life, liberty, or property, or some combination of the three. Whether I choose to comply or not, it's going to harm me in material ways. And yet, Article 1, Section 1, Clause 1 says that all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Article 1, Section 7 makes abundantly clear what Article 1, Section 1 sets up, which is to say you cannot make a federal law without the assent of both the House of Representatives and the Senate on the same bill. They've got to pass the same bill text and then present it to the Chief Executive, the President of the United States, for signature, veto, or acquiescence. Unless you follow that formula of Article 1, Section 7, you're not supposed to be able to make a federal law. One of the more influential political philosophers on the founding generation is Charles de Montesquieu, who observed that the lawmaking power is itself non-delegable, that the task of lawmaking involves the power to make law, not other lawmakers. Because as we see to this very day, when these things happen, when people come back to complain to us that the administrative regulation carrying the force of generally applicable federal law when it causes problems, people come and complain to us, and then members of Congress predictably and foreseeably beat their chests and they say, oh, yes, those barbarians over at agency, commission, Department Y. We didn't mean to authorize this. We just said make good law as to issue X. We didn't say to make bad law. And then predictably, the senators, the representatives say something like the following. You know what I'm going to do for you, constituent? I'm going to write them a harshly worded letter. That's what I'm going to do. As if that were our job that we were sworn in to do, were to write harshly worded letters. It's not that, of course. It's to make laws, not other lawmakers. I keep these two stacks of documents behind my desk. One stack is small. It's usually a few inches, no more than a foot or so. Consists of the laws passed by Congress in the preceding year. It's just a few thousand pages long. The other stack is 13 feet tall. During a typical year, it'll reach about 100,000 pages stacked up even on very thin paper, double-sided, small print, about 13 feet tall. Consists of last year's Federal Register, the annual cumulative index of these federal regulations as they're promulgated, as they're initially released for notice and comment, and later as they're finalized. Those rules carry the force of generally applicable federal law. Failure to abide by those can shut down your business, can result in enormous fines. In many cases, can result in your imprisonment if you don't follow them. And yet they are not enacted themselves through the formula prescribed by Article 1, Section 7. No, because in that instance, we've authorized the making not of laws, but of other lawmakers, not ourselves. And those other lawmakers to whom we've given this assignment, while perhaps, however well-educated and well-intentioned, wise, specialized, well-trained they might be, they don't stand accountable to the American people, ever. Their name will never appear on a ballot. In fact, their name will stand essentially as a secret to nearly every American, including those who will stand accountable to those laws, who may lose life, liberty, and property as a result of those things. It's not right. We all know deep down that it's not right. We know that every time we're presented with one of these complaints by our constituents, and we all have them. In my office, it's a nearly constant refrain. And yet they often precipitate the predictable, harshly worded letter and not a lot else. In other instances, they might culminate in the filing of a resolution of disapproval under the Congressional Review Act. As fun as those can be, because they do give us at least an opportunity to debate them, those are privileged resolutions. You follow the rules of the Congressional Review Act, you can pretty much always get one of those voted on. You can at least have an opportunity to present those here in the United States Senate and to vote up or down as to whether or not you want to disapprove of the regulation in question. Ultimately, however, those proved dissatisfying from a constitutional standpoint, in the sense that, with very narrow exceptions, they don't really do any good, because nearly any administration whose bureaucratic structures will promulgate the administrative rule in question will like, for policy reasons and political reasons, a policy choice embodied in those regulations. And consequently, the president, whose administration promulgated the regulation being challenged under the CRA resolution of disapproval, will almost always veto any resolution of disapproval passed by both houses of Congress. It's very rare that that doesn't happen, with only one exception I can think of from a few decades ago. The only time that works, other than that one exception that I'm thinking of, occurs when a holdover, when you've got a new administration and you've got regulations that have been promulgated toward the tail end of the previous administration. We had a number of those when President Trump took office. Following President Obama's time in office, where regulations from the Obama era were becoming ripe for CRA resolutions of disapproval, and we were able to get them passed by both houses of Congress and then signed by President Trump. Those circumstances are pretty rare. In every other circumstance, the voters of this great country, those subject to these administrative regulations that are, in fact, laws, those things leave us without redress. It's one of the reasons why I've long advocated for us to pass a measure called the REINS Act. If a genie appeared to me and said you can pass any one bill now pending in front of the United States Congress, it'd be the REINS Act. Why? Well, because the REINS Act would require us by statute to do what I believe the Constitution already requires, what it in fact does contemplate, which is that it's fine for administrative regulations to be promulgated, to be proposed, but unless or until they're affirmatively enacted into law by both houses of Congress and then signed into law or acquiesced to by the sitting president, or in the event of a veto, if that veto is overridden by 2/3 of both houses of Congress, then it can take effect. But short of that, no dice. You don't get a law. These do have far-reaching effects, including the fact that, as a member of the Judiciary Committee, I and a few of my colleagues tried to figure out a few years ago how many criminal offenses are on the books, how many different provisions of federal law prescribe criminal penalties and can result in a criminal conviction. We asked this question of the Congressional Research Service, the the entity to which we turn regularly in order to get answers to questions like those. The answer came back to us in a way that I found absolutely stunning. The answer that came back to us from the Congressional Research Service, very talented people at the Congressional Service who were very good at answering these questions. They did a good job doing it, and I'm convinced they gave us the answer that was possible to achieve. They said the answer is unknown and unknowable, but we know that it stands at least 300,000 separately defined criminal offenses on the books. Now, this does not mean that on 300,000 plus occasions, both houses of Congress passed into law a separate statute defining a criminal offense with criminal penalties. No, in many, many of these instances, one of the reasons why the number is so difficult to tie down is because a lot of these are defined administratively. So that's one area in which the United States Senate has been deliberately shirking its responsibilities and handing them off to somebody else, refusing to do the job that we've been given to do. We've also, so that was on the legislative calendar. We've done that time and time again, also on the executive calendar, where we've changed the law so as to limit, changed the law or in some cases adopted standing orders that have been embraced in subsequent iterations of the Senate, limiting the number of presidential nominees requiring confirmation. So we've narrowed our playing field there, too, shirking our responsibility, even as the size of the federal government has increased inexorably. We've narrowed our job. And now we've seen it done again today in our third state of being, in our third category, where we operate as a court of impeachment, where even here, where our job is really limited, we have one job in this area: to conduct impeachment trials. There are 1,000 ways you can conduct an impeachment trial. You can conduct an impeachment trial with the whole Senate. You can specialize the impeachment trial so that it's heard in the first instance by a select committee with members of both political parties who hear the evidence and then after doing that, submit the whole matter for a final vote to the whole Senate. You can hear evidence through individual witnesses. You can receive evidence in documentary form. There are 1,000 different ways to conduct a trial, some of which allow the trial to be conducted pretty quickly. Others might take more time. But there are 1,000 ways we can do it. And here, as with the other two states of being, first on the legislative calendar, then on the executive calendar, now as we sit as a court of impeachment, we've narrowed our work again, shirking our responsibilities again, declining to perform our constitutional duties. This is shameful. I'm embarrassed that we as a Senate seem so enamored with the idea that we can't do the things given to us. What's especially troubling about this is that, we are, in fact, a government of limited enumerated powers. Our job is not to, as some people put it, or run the country. Our job is not to make law on any matter that we think appropriate or significant. Our job is not just to enact legislation in any area where we think it might redound in one way or another to the net benefit of the American people. No, we're supposed to be a government of limited enumerated powers, charged with a few basic things. We're in charge of a uniform system of weights and measures, a system of immigration and nationality laws, regulating trade or commerce between the several states with foreign nations and with Indian tribes. We're in charge of declaring war, establishing and regulating an Army and a Navy, coming up with rules governing state militias, which we now refer to as National Guard, coining money, regulating the value thereof, coming up with bankruptcy laws, postal roads, post offices, regulating, in some instances, federal land to be used for some military purpose, regulating what we now call the District of Columbia, adopting rules governing the disposal, the regulation and disposal of territory and other property owned by the United States. Then there's one of my favorite powers of Congress. Involves granting letters of marque and reprisal. Marque, in this instance, spelled M-A-R-Q-U-E. We haven't done one of those in over a century. I hope we will sometime. I think we should. Letter of marque and reprisal is basically a hall pass issued by Congress that allows those acting pursuant to it to engage in acts of piracy on the high seas with impunity offered by the United States if they're able to make it back with whatever loot they take into the United States, and then divide the spoils and share the spoils with the United States government. And that's about it. And there are a few other powers of Congress here and there, but that's the lion's share of what the federal government can do. And of course, we occupy the most significant, prominent, dominant, and dangerous power within that because we're the lawmaking branch. We make the laws. The executive branch enforces the laws we make according to our policies and enforcing the policies that we enact. The judicial branch, headed by the Supreme Court, just interprets them, not just in the abstract, but interprets them in a way so as to be able to resolve disputes properly brought before the jurisdiction of the courts, disputes over the meaning of federal law. So we've got the most dangerous, prominent, dominant position. It makes sense that the Founding Fathers entrusted that role only to us because we happen to be the branch of government most accountable to the people at the most regular intervals. You can fire all 35 members of the House every 2 years. You can fire 1/3 of the body, the members of this body, every 2 years. And it's one of the reasons why the Founding Fathers considered the power that we wield the most dangerous, because they made us subject to the most frequent and regular and direct kinds of guarantees of accountability, that is, through elections. So now we've got somebody who's been impeached because a law that we passed that he was charged with enforcing and administering and implementing and executing didn't do his job. So it falls on us to decide that. We've got myriad instances in which that violation of the law can't be adjudicated in court, such as this case we referred to earlier, United States versus Texas, where a majority of the Supreme Court of the United States, against, by the way, a brilliant dissent by Justice Alito, concluded that the state of Texas didn't have standing to address the violations of law, the deviations from law of Secretary Mayorkas and the Biden administration. So if not us, who? In countless instances, the courts can't do it. The executive branch isn't going to check the executive branch. The buck stops with us. It's our job to do this. And today we failed. We didn't just fail in the sense that we tried to do it and we didn't. The majority of us, unfortunately, tried not to, went out of our way to define our role as something that it's not, to define the law as saying something other than what it in fact says, so that we can shirk our responsibilities yet again. Shame on us, shame on those members of this body who voted to do that today. I wonder what future generations will say about this. I wonder how many ways in which future generations will suffer from what we did today. I hope to shout that they'll take this as a lesson in what not to do and soon depart from this awful precedent, because otherwise this will lead to the shedding of tears and worse. We're told that the Senate is apparently just too busy to conduct an impeachment trial, just as we're about to be told that the Senate is too busy to require the federal government to get a warrant before searching the private communications of the American people incidentally collected and stored in the FISA 702 databases. Too busy to do those things, but I think we're about to be told that it's not too busy to send even more money to Ukraine, where we've already sent $113 billion. Not too busy to do that. Not too busy to expand FISA without adding a warrant requirement, but just way too busy, apparently, to do what the Senate and only the Senate can do, and what under the Constitution we must do. Madam President, like the ghost of Christmas future in Charles Dickens' A Christmas Story, I hope that as we examine our future and what today's action portends about the future of the United States and of the United States Senate, I hope we can choose to depart from this course. While I fear that our past will prove to be our prologue, I sure hope we won't solidify and more deeply entrench this unwise, indefensible move that we took today. But I'm glad we've had the chance today to set the record straight, to make an adequate record of what really happened. And that while a majority, a bare, slim majority, chose to excuse the inexcusable today, some of us, nearly half of us, tried to stand in front of that train and stop. I hope that this will prove to be an aberration. Let's all pray that it does. Thank you, Madam President. I yield the floor.
President.
The Majority Leader.
I have 8 requests for committees to meet during today's session of the Senate. They have the approval of the majority and minority leaders.
Duly noted.
Madam President, I have unanimous consent that the Committee on Environment and Public Works be discharged from further consideration of H.R. 4389 and the Senate proceed to its immediate consideration.
The clerk will report.
H.R. 4389, an act to amend the Neotropical Migratory Bird Conservation Act to make improvements to that act and for other purposes.
Is there objection to proceeding to the measure?
I ask the bill be considered read a third time.
Without objection, the committee is discharged and the Senate will proceed.
I ask that the bill be considered read a third time.
Without objection.
I know of no further debate on the bill.
Is there further debate? If not, the question is on passage of the bill. All in favor say aye.
Aye.
All opposed, no. The ayes appear to have it. The ayes do have it. The bill is passed.
I ask unanimous consent the motion to reconsider be considered made and laid upon the table.
Without objection.
And finally, Madam President, I ask unanimous consent that when the Senate completes its business today, it stand adjourned until 12 noon on Thursday, April 18th. That following the prayer and pledge, the morning hour be deemed expired, the journal of proceedings be approved to date, the time for the 2 leaders be reserved for their use later in the day, and morning business be closed. That upon the conclusion of morning business, the Senate resume consideration of the motion to proceed to Calendar 365, H.R. 7888.
Without objection, so ordered.
If there's no further business to come before the Senate, I move that it stand adjourned under the previous order.
The question is on the motion. All in favor say aye.
Aye.
Those opposed, no. The ayes appear to have it. The ayes do have it. The motion is agreed to. The Senate stands adjourned until 12 noon tomorrow.